All right. Good evening. No, technically, Anush, that is not true. Yesterday, a lot of you were able to, right? Yes. Yesterday, a lot of you requested that you may have a lot of academic workload. So just wanted to clear a few things out so that it's easy for you to understand that from Tuesday till at least Sunday, we will have class from 4:30 p.m. onwards, and the institute will ensure that except your optional class, if you have taken any optional class from the institute, there will be no other GS class except for polity in these coming days, so that you don't feel academically burdened and you are also having enough time to self-study in the leftover parts of the day. Several students had brought it to my attention yesterday and day before, stating that because of a high number of classes on a daily basis, you are not able to get time to prepare and study on your own. So this is exactly how we're going to run the rest of the course for you, at least till Sunday. Now, we had covered yesterday the electoral comparative review and the composition of office comparative review of the president and the governor. We are now going to spend some time on the powers as far as the president and the governor is concerned. And when we do study the powers of the president and the governor, we are going to understand a very limited section of powers, because a lot of these powers overlap with other organizations. All right, a lot of I don't think so, Ankit, you don't have any other class, right? They've informed me that there is no other GS class. I just spoke to them about 15-20 minutes ago. Notes are enough. Now, when we study the powers, well, technically, there are essentially three kinds of powers that we largely refer to. You have your legislative powers, you have your executive powers, and of course you have your judicial powers. Now, in either of these three cases, there are essentially two kinds of powers that often come into question, that are things that we must need to know. They will rectify it, don't worry. That's what I've been informed. Okay, so don't worry, we'll take care of this. Anyways, so there are essentially two kinds of powers. One is, of course, powers which are routine in nature, which are procedural in nature, and second, powers which are substantive in nature. Okay, right? They're largely substantive in nature. Now, what we're going to do here is we're going to understand the extraordinary powers, or we're going to understand the kind of special powers that primarily exist for the president and the governor. We will not look at a lot of procedural powers here, largely because they will have an overlap with parliament and state legislatures separately. So, for example, dissolution of a house, prorogation of a house, calling of a session of a house, calling for a joint session of the house, motion of thanks. See, all of those are better understood when we are actually studying the parliament, and which we will start in the next day or so. So that is something you don't have to particularly worry about. When we come to the parliament and the legislatures, we will understand those kind of, procedural, substantive, ceremonial powers. What we now have to fundamentally focus on are powers which are extraordinary in nature, powers which are specialized in nature, and powers which of course have a degree of intrigue value. Right? So what is it that we're going to study, and how much of this is actually asked as far as the prelims is concerned? Now, we are going to be looking at two kinds of legislative powers. The first, of course, are legislative powers with respect to the veto. A veto is a nullifying vote. A veto is usually a single negative vote. So we'll understand the concept of this. And apart from this, we will also understand ordinances, right? Now, ordinances is something which is important for both pre and the mains, and therefore is important for layer 1 and layer 2 combined. So we will do this together. And ordinances is also an application of separation of powers, which is a direct part of your main syllabus, and in fact is a question mark or a negative effect on separation of powers. So we are going to cover this in a sufficient amount of detail as well today. Right? So this is what it is that we're going. These are the two primary powers that we will be referring to. Apart from that, when you have these sort of other legislative powers, such as a prior recommendation, right? In terms of powers with respect to the houses, such as dissolution of a house, such as prorogation of a house. I know you don't know what these terms mean. Don't worry. When we cover the parliament and the legislature, we will understand these terms in a fairly good amount of detail, and it'll be easy for you to understand these powers then, and we'll cover them as well they're placed. Right now, when we look at the executive powers of the president, we're going to essentially understand a very simple application, which is discretion. And this is something you must get right. We're going to understand discretion-based powers as far as the president and the governor is concerned. Now, we understand that both the president and the governor are usually bound by the advice of the president of the council of ministers respectively. But the question is, under what circumstances are they not bound by the advice of council of ministers? Which are these kind of circumstances? Why do these circumstances exist? And how are these circumstances actually used? In this, we will understand two kinds of discretionary powers, wherein we will first understand constitutional discretion. We will first understand constitutional discretion, which means powers which are explicitly discretionary powers which are explicitly mentioned in the constitution. Or we will understand discretion which arises out of a situation, out of a sense of helplessness, that there is no other way out, and that is why we have to do what we have to do. Now, discretion simply means taking a decision using your own wisdom, your own application of mind. You are not you're not bound by the advice of somebody else. You're not bound by the discretion, by the law, by an authority, or by anybody else. It's simply but a decision taken upon application of one's own wisdom. Right? So this is something we will understand. Apart from this, we will also look at certain judicial powers. When we talk about judicial powers, we are primarily going to be looking at powers with respect to changes in the punishments that are awarded by the courts. In this scenario, we will look at the two basic changes that usually happen. First is you change the method of punishment, and the second is sometimes you change the tenure or the extent of the punishment. Again, your background powers, which are largely procedural in nature, like for example the executive powers or the ordinary executive powers, which are exercised by the president on the governor, like appointment of the council of ministers, such as administering oath in a select few cases. All of these are ordinary powers. When we cover council of ministers right after this, I'll take that up into account. Similarly, appointment of Supreme Court, High Court judges, their role in the collegium process, are some of the or certain advice that they are going to seek from the Supreme Court in the form of advisory jurisdiction. Now, these are topics that we will cover as a part of other topics. Like, for example, we'll cover all of this as a part of the Supreme Court, which we will discuss as the judiciary in just some amount of time. So this is largely how your division of powers have to be understood. We will spend a lot of time on ordinances because they are asked in the mains. There are direct questions that are asked from here. As far as the notes are concerned, notes for all of this, as far as the pre is concerned, handwritten form, you will find them on the drive. And as far as notes for ordinances for the mains are concerned, you will find this in syllabus number 3 of the mains updated folder, wherein I've also added a lot of data. I will cover this in today's class as well. So this is largely what our plan of action is, and we should be able to understand most parts of it in a fair amount of detail. Right? Now, let's start with the first legislative power. Before I forget, please, you can take a note of this. It'll be easier for you to map it when we are studying the powers. I'll give you about 2 minutes to take a note of this. Supreme Court, Ankit, and don't ask me factual questions that you could have read from a book. I will anyways cover that once we are done with the review of the offices. So you've got 1 more minute. Collegium, appointment of Supreme Court, and Supreme Court advisory jurisdiction. All right. Let's start with veto powers. What you must understand at the very beginning is this, that the word veto is not mentioned anywhere in the Constitution. This is an informal word that we use in our reference books, in our guidebooks, but the word veto is not mentioned anywhere in the Constitution. The simple understanding of veto is a single nullifying vote. You would have definitely seen the application of veto in the UN Security Council, where the P5, the permanent 5 members of the UN, have what is called a veto. Now what happens here is, suppose there is an issue X on which all the members of the UN, there are permanent and non-permanent members both, are voting. Even if any one of the permanent members says no, then the Security Council cannot implement action on that issue. So it's a single nullifying vote. You will often find this in several democratic systems. You will find this in several parliamentary and other organizational systems. Now, with respect to the president or the governor, let's understand the basic ecosystem. Now, let's say talk about the center. Now, usually what happens is that the Lok Sabha has passed a bill. Then the Rajya Sabha has passed a bill, and after that it has been sent to the president for the word called assent. Right? Now the president primarily has 3 choices. Either the president gives assent, which means says yes, or the president does not give assent or rejects the assent. This means no. And the third is, the president can sometimes return the bill to the legislature, which means it goes back to the houses, right? So we are looking at these 3 options. As far as the states are concerned, now let us assume that we're only talking about states with legislative assemblies, because there are very few who have a legislative council. So again, what happens at the level of the states is, the state legislative assembly has passed a bill. It has then reached the governor. Now, unlike the president, the governor has 4 options. The first 3 are similar. The governor gives the assent. The second is the governor rejects. The third is the governor returns. And the fourth is the governor reserves. Now, this means the governor is going to now send it to the president. The governor is going to now send it to the president. This is reserving for the president. Reserving for the president. Okay? Now, these are basically the kind of options, the kind of sort of framework that exists as far as your ratifications or your assent is concerned. Okay? Now, so what is mentioned is the word assent and not veto. Let's understand now what is it that they can say yes to, what is it that they can't say yes to, and so on and so forth, right? So the basic understanding here is that the president obviously can say yes to all kind of bills, right? I'll just make this slightly better. The president can say yes to all kinds of bills, absolutely all kinds of bills. And the president can say yes to all bills, but has to say yes, does not have an option, has to say yes to a constitutional amendment, has to say yes to a constitutional amendment, which also means the president cannot say no to a constitutional amendment. Both of these statements are correlative. If you have to say yes, then you can't say no, which also means you cannot return a constitutional amendment. The president has absolutely no choice but to say yes as far as a constitutional amendment is concerned. Now let us understand why. The question is, why does the president have to always say yes to a constitutional amendment or a constitutional amendment bill? Why is this the case? This is the case for a very simple reason, and that is Article 368 gives the power to the Parliament to change the Constitution. It does not give the power to the President, right? Now, if you had to argue the opposite, if you had to say that the President had the powers to say no to a constitutional amendment, then in that case, the President could override the Parliament with respect to a constitutional amendment, and thereby it would question what is called parliamentary democracy and would make us closer to a presidential democracy. And in India, parliamentary democracy is supreme. See, the Constitution is not like any other law. You want to pull the plug on any other law, we understand there could be reasons. But here we are talking about the law which gives powers to the president itself. So tomorrow, if the Parliament had to make a law reducing the powers of the president and they're already negligible, the president could obviously say no to that law, and that law would obviously be a constitutional amendment because the powers of the president are mentioned in Part 5 of the Constitution. So this is why the president absolutely under no circumstances can say no or can return a constitutional amendment bill, right? Now, you would then ask, what about the states? You see, and you would recall that a very specific type of constitutional amendments under 368 require state ratification. This is also what is called popularly special majority 3, right? Now, what about the role of the governor here? You see, the governor has nothing to do with constitutional amendments. If, let us say, we're applying special majority 3, both the houses have passed it through special majority 3, it will be sent to all the legislatures. Half of them have to ratify the same with a simple majority and directly send it to the president. The governor does not get back. right? The governor does not get in the middle of this. The governor has no role to play in the assent or the non-assenting procedure of constitutional amendment. So we don't have to worry about the governor at all. Okay, so that's the first part. The second part is something also very interesting. Now we look at money bills, right? Now the basic provision here is that as far as the money bills are concerned, the president can either say yes or can say no, but the president cannot return a money bill. The president cannot return a money bill. You can either say yes to a money bill, you can either reject a money bill, that is fine, but you can't return the money bill. And let me just very briefly tell you why that is the case. I will repeat, I will teach you the details of the money bill in Parliament. This is just to explain to you the veto process with respect to the money bill. Okay, now in a very simple way, if you have to understand what a money bill is, see, a money bill is under Article 110 of the Constitution. This is an important article number, which is why I'm giving you this article number. Now, a money bill is basically about increase or decrease in taxes, which the center can make on, increase in decrease of the Consolidated Fund of India, right, or the Contingency Fund of India, and increase and decrease of parliamentary guaranteed borrowing. Broadly, this is what a money bill is, right? Anything which basically just has a difference to the amount of money, right? So for example, if you're increasing your, and this is increase or decrease of existing taxes, and this is increase or decrease of money into the consolidated or the contingency fund. This is nothing but where all the government money is kept. Contingencies, of course, an emergency fund out of the consolidated fund. We'll do all of this in detail later. Now is not the time to worry about it. The basic point here is that this basically only affects money. This basically only affects money, and I understand that, I appreciate that. Now, what is the basic procedure here? The procedure here is, firstly, anyone can introduce a money bill. That's not a problem. The first thing is, the Speaker of the Lok Sabha or the State Legislative Assembly must give a certificate that yes, the contents of the bill are indeed worthy to be called a money bill. Then it is sent to the President, and then the President orders for the bill to only and only be introduced in the lower house, which is the Lok Sabha. This becomes the governor and the state legislative assemblies as far as the states are concerned, respectively. We'll come to that when we do the parliament, right? Now, after the Lok Sabha has passed the bill, it goes to the Rajya Sabha, and the Rajya Sabha gets 14 days for it. Okay, the Rajya Sabha gets 14 days for it. The Rajya Sabha cannot say no to the bill. They cannot reject the bill. They don't have an option. They have 14 days to suggest any amendments, to suggest any changes. They send these changes back to the Lok Sabha. If the Lok Sabha agrees, well and good. If they don't agree, then it has overridden the Rajya Sabha, and the bill is then sent back to the President for assent. Okay? So the Rajya Sabha cannot say no, it cannot reject the money bill, it can either say yes or it can recommend certain changes. Now, This is a simple process and the Lok Sabha can then authorize it. All money bills, no matter what they are, they will always require simple majority, even if they are for the center or even if they're passed at the level of the states. Budgets, as I've said before also, are extended forms of money bill, which is why you will notice that even currently when you're in the union budget, the Appropriation Act is also a kind of a money bill only. We'll come to that later, don't worry about it. So what is the basic premise? First is that there is an application of what is called rule number 2, which is center stronger than the states. Now you see, the parliament here, and more specifically the Lok Sabha, which has the majority of the government, gets to make these changes to national financial policy. So tomorrow, if the government increases, right, if the government increases their income tax, right, the central government does that, and the central government has the powers to increase the income tax. This will affect the entire country, but the central government has the powers to impose income tax because the powers to impose and to collect income tax, it's a direct tax, but collected by the center. Right. So this is rule number 2, center stronger than the states, that the center has the powers to have such a national financial impact as a whole. Right. Now, once we understand this, this means the states have no options but to agree to this, which is why the center is stronger than the states. Now, what are your hollow candies? The first is that the Rajya Sabha does not get equal powers like the Lok Sabha with respect to a money bill. For everything else, for every other bill, the Lok Sabha and the Rajya Sabha have fundamentally equal powers. They have fundamentally, categorically, crystal clear equal powers. Crystal clear equal powers. However, with respect to a money bill, they don't, because Rajya Sabha is a representation of the states. And if we allowed the states to have an equal say in the financial policy making of the center, it would be against the interest of unitary federalism, especially when the states have their own money bills to look into. That means the states directly would be looking after their respective money issues and also having an effect on the national financial policy, which is why the Rajya Sabha has been given a diminished role. Now, this means that the center here, or the government of the center, who has majority in the Lok Sabha, would obviously seem to be at an advantage because they do not have to worry about the wrath and the dissent of the Rajya Sabha in case they don't agree with a bill. If it was any other bill, the Rajya Sabha could reject the bill and it could be a situation of a deadlock. But here, the government is absolutely confident that we can sail through this easily and we can get to our assent, which is why the first check here is the speaker. The speaker is supposed to be politically neutral. Unfortunately, is often not entirely politically neutral, and that is why a speaker's certificate is needed, as a result of which you're able to decide that yes, this is a money bill, and this can technically, bypass the Rajya Sabha in a manner of speaking. This speaker's decision to certify a money bill has been called into question very recently on two extremely important circumstances. One was when the speaker had certified one of the Aadhaar laws as a money bill, which was then challenged in the Puttaswamy judgment and the right to privacy was born. And second was the issue where in the Finance Act of 2017, which is one of the other two laws that you pass as a part of the budget, the speaker had also that Finance Act contained certain provisions with respect to the tribunal powers to be governed by the government, and because it was a money bill, you ended up by passing the Rajya Sabha for it. So these are the two reasons why the intention of the money bill has been questioned in the last 5 years or so. And this, of course, led to the Roger Matthews case, which gave very clear judgments, which also led to the Supreme Court saying we need a National Tribunals Commission. This also led to the judgment wherein the Supreme Court curtailed these tribunal provisions, led to several tribunals in 2021 to have been abolished by the government, and the Censor Board Tribunal was in fact one of them. So that's the first candy. The second candy is that the president is elected by both the centers and the state, and therefore the president by law is an apolitical body, and it is the president through which the bill is being formally introduced on the floor of the House. And after all of this is done, the president will still have the powers to either say yes or say no, but the president cannot return, because even if the president returns it to the houses, it is the government who can easily pass the law in the exact same manner, and therefore it will not make any difference. So why has the president been given the powers to actually say no? Because what if enough time has passed and you don't need that financial change anymore, or circumstances have changed where the financial change is no longer necessary? So for those reasons, it has been understood very clearly that the money bill has a special role to play as far as legislative circumstances are concerned. So which is why, as far as the president is concerned, you can say yes or you can say no, but you cannot return a money bill, which also means you cannot return a money bill, and these are similar powers as well. Okay, similar powers. Otherwise, they can the governor reject a money bill? Absolutely, no problem at all, no worries about it under any circumstances. Okay, so this of course is clear. We understand why the second question is, why does the governor, why does the president or the governor not have the powers to return a money bill? Now, clear on this. Avinash, learn to ask your question when there is the time to ask a question. An Aadhaar bill is a law which has been passed by the House. I am assuming by now you would have understood that laws could be challenged in courts, right? Anyways, so that is the case, and which is also why the Supreme Court very clearly held that I cannot question the reasoning behind which the speaker gave the decision to certify something as a money bill, but I can certainly question the material reasons that the speaker relied on for deciding the same. Right? So please hold your tongue, turn and ask a question when the time is right to ask a question. Okay, so we are clear with this now, sorted. Now we come to the governor. Now everything else sort of remains the same, but there is something very special as far as the governor is concerned. And what is special about the governor is concerned is that the governor can reserve any bill that the governor wants to for the assent of the president. The governor can reserve any bill that the governor wants to for the assent of the president, and then the president can perform either of the three functions in place of the governor. The president can perform either of the three functions in place of the governor. Now, similarly, how the president had to say yes to a constitutional amendment, similarly, the governor does not have a choice. The governor has to necessarily reserve a bill which changes the powers of the High Court, which changes or alters the powers of a High Court. If this is the case, then the governor has to necessarily send it to the president, and then of course the president can look into it on behalf of the governor as a whole. Right? Now, this requires a little bit of understanding, so let's spend some time with this. So your first question in your mind should be, what kind of a bill can be passed by the states that changes the powers of the high courts? This is the first question, the most fundamental question you should have. Why? Because, and this is important here, because Devendra, please be patient, don't interrupt the flow of the class. This is the last warning to you, otherwise I'll throw you out of class. Now, very clearly, let's understand this with respect to the powers of high courts, and let's get this right. We understand that the Supreme Court and the high courts are collectively called higher judiciary. They are appointed and removed by the parliament, and India also believes in what is called an integrated sort of a judiciary, right? So what are the kind of laws that the states really have the powers to make on? So firstly, the states do not have the powers to directly change the powers of the High Court. Directly change the powers of the High Court. The state cannot do that. It is actually with the center. What the state can do is something rather indirectly. And what is indirectly? Indirectly is this, which is, suppose, let us say, land is a state subject. This means when you make a law on land, this will also include land disputes. What if a specific state makes a law and says land disputes will not be heard at high courts but only at district courts? So this is indirectly changing the powers of the High Court through this route, which is why there's a very popular doctrine in constitutional law which says what can't be done directly also can't be done indirectly. Also can't be done indirectly. Okay? So what ends up happening in this specific scenario is that through an indirect mechanism, the states might want to do this. The law will reach the governor, and the governor will necessarily have to reserve it for the president. Now, this means that the governor has no choice but to reserve a high court power change law to the president, which means the governor cannot reject a high court power change law either. And the governor also cannot give consent to the High Court power change law, because in this scenario none of this can be applied. You will have to, and you cannot return a High Court power change law, right? So this means you cannot do any of these three things, either give consent, reject it, or return assent with respect to a High Court power change law, and this has to necessarily be sent to the president. So it's actually that simple, right? Now, there are 2-3 more background concepts that often come to mind when we have to understand it. So the first question here is with respect to a time limit. Now you see, the Constitution does not prescribe any time limit, which means once the law has reached the president or the governor, they can तोरा यहाँ नहीं, वहाँ अंदर वाले बेड पे होगी, नहीं कोई नहीं, खाना दे देना उसको, है ना? हाँ, right. So yeah, sorry, my dog. Okay, right. So no time limit whatsoever, wherein of course they can decide, take all the time. So the first question is, why is there no time limit? There is no time limit because when you are deciding, when you are giving your assent to a law, which means that once the president has given their assent to the law can be brought into force, it can be implemented. And deciding whether a law can or cannot be implemented is very similar to the courts deciding whether a law should or should not be implemented. If you think about it, the president or the governor deciding whether a law, whether to give an assent or not, is to basically decide whether the implementation should begin or not, and the courts decide whether the implementation should continue or not. But the subject matter of both the discussions largely remains the same. So if the courts and the president are largely making the same decision, but in two different circumstances, in two different contexts, we can't treat them differently. We don't pressurize the courts who are deciding the validity of a law to decide it within 10 days or 15 days. You can have fast track courts, but fast track courts don't determine the validity of a law. They determine the applicability of it. But with respect to Supreme Court or High Courts, you can never force them to give a decision in a specific amount of time, because fundamentally it would violate the principles of natural justice and of course the rule of law, which is why there are no time limits. Now, this does not mean that you can abuse these time limits. So what happens sometimes is that if you apply rule number 1 to the tenures and the bills of the lower houses, we understand that there's something called a term. Like for example, we are in the 17th Lok Sabha, which is from 2019 to 2024. Now this is the term. Okay, and when you apply rule number 1, democratic mandate, it simply means anything introduced, passed or pending only in the Lok Sabha or the legislative assemblies ends with their tenure. So if there is a bill which was introduced in the Lok Sabha and is pending in the Lok Sabha, or has only been passed by the Lok Sabha, in such a scenario, once the Lok Sabha has ended, the bill ends up being lapsed. right? So now let's understand a similar concept here. So a lot of times what happens is the president tries to use a similar sort of an advantage to its use. In this case, both the houses have passed. The president has the bill. The president sits on that bill forever until the Lok Sabha dissolves, and then literally forgets about it. Or the new parliament comes up with the new Lok Sabha comes up with a new bill which the president signs on, right? So this is also in your common guidebooks called a pocket veto. So that's the first part that we must understand. So now your question would be, sir, in that case, with respect to a money bill where the president has to say yes or has to say no but can't return, so can theoretically the president sit on the money bill for eternity? Yes. Can the president sit on a constitutional amendment bill for eternity? Yes. But the second the president does that, it violates the principles of the constitution. The articles of the constitution would say that the president must give their assent to the constitutional amendment, or can choose to either give or reject their assent to money bills. And that could be a grounds for impeachment of the president if the president is trying to act smart by just sitting on the constitutional amendment bill. Okay, so this is of course how it works. Now the second question, the second background question that we would have is, if they are bound by the advice of the Council of Ministers, right, then they must say yes. You're right. Then they can't say no to anything. But again, they are not bound by a time limit to implement that advice, which is why the president can sometimes, take as long as they want. But what if the Council of Ministers have said, please sign, and the president says no? In such a scenario, the president is indeed violating is still not abiding by the advice of Council of Ministers. Okay. Now, in usually these cases, if the president is saying no to a bill, is rejecting a bill, that could be grounds of impeachment, because the president is trying to, sort of overpower the parliament. So that is of course the case. But let's understand why this actually happens. Suppose this is 2024 and the 17th Lok Sabha and the Rajya Sabha passed a bill and reached the president. There were of course the Council of Ministers here. Now halfway through 2024, we have a new Lok Sabha. So from 2024 to 2029, we are going to have the 18th Lok Sabha and the Rajya Sabha will continue. Now let us say there was a bill, the Council of Ministers gave advice to the president, and the president said okay, but in the meantime this changed, but the bill was still here, and the new Council of Ministers now said no, don't do it. The president can still say yes. The president can, if they say yes, the president can still say no, right? But of course the president is still bound by the advice of Council of Ministers. In fact, very interestingly, this part is undefined in the Constitution. This is a gray area. The Constitution says the president is bound by the advice of Council of Ministers, no doubt. But what about a scenario like this? Can the president say no? Well, theoretically, yes, they can. So for example, can the president also say no to an ordinance? Theoretically, yes, but it would violate the principles of parliamentary democracy, which is why the presidents usually don't do this. They usually perform what is called a pocket veto. Now, the second part is what happens. Now, the third issue is after returning the precedent, the bill comes back. In this case, they have to necessarily say yes here also, here also. But again, no time limit is required or no time limit is mentioned. In your standard textbooks, return is called a suspensive veto. This time limit concept is called a pocket veto, right? Then you have rejecting is called absolute veto. That's the basic difference. And has this happened previously in the constitutional history of this country? Yes, there have been a few times, such as the Pepper Appropriation Bill, where the president has exercised certain provisions or certain powers with respect to the veto. Now, this is largely how the ecosystem works. I think it is fairly simple. I will summarize it for you. The president has to say yes. The president can't reject a constitutional amendment, can't reject any bill which is the constitutional amendment, otherwise can reject everything. The president can't return a constitutional amendment and can't return a money bill. The governor can give a consent for everything except High Court power change law, can reject everything except a High Court power change law, can return everything except a money bill and a High Court power change law. This is very similar to that of the president, and the governor has to reserve a bill for the assent of the president if the bill affects a High Court power change. Which is why I often tell you, let me finish the topic first, then you can ask me your questions, because very likely I would have thought of these and I would have anyways answered them in the course of the class. And this covers what is called our primary veto powers. I'll give you about 5 minutes to take a note of all of this. If you have any questions, you can post them in the comment box, and thereafter we will continue with ordinances. The answer to the second question is because it would be legislatively redundant, as the Council of Ministers enjoy majority of the Lok Sabha. Wagmare. The President can reject the money bill, cannot return a money bill. Then the houses can either choose to pass it, change it, pass it in the same manner or not. Tabrish. Yes, Tabrish. Nikhil, that is also one of the arguments, because the financial circumstances may have changed, which is why they have been given the powers, Nikhil. There are no constitutional provisions. I just told you it's a grey area. Then the president can, in Hussein, then the president can refer it, can accept it or can reject it, can't return it to the state legislatures. All right. Okay. If the president says no to any money bill, what next step shall we take? It will not pass, obviously. Is it necessary that acting? Yes, it is unconstitutional. If the state legislature does not have a law on a matter, does it follow the rules? Simran, don't quote me a previous year question from the prelims. When I come to the parliament, I'll discuss this. So, why president or governor can't return the money bill? Because I've answered the question just right now. High Court power is if there's any bill passed by the legislature of the states which amend the powers of the High Court, then in that scenario, the governor has to reserve it for the president. There is no time limit at all. Sometimes the president can or the governor can just sit on the bill until the Lok Sabha dissolves, and maybe the new government that comes in may not want the bill to pass. Yes, Ritik. All right. Now, we move to the second power. This will be done in an analytical format, both for the pre and the mains. So let's spend some time on this. We are going to now be discussing ordinances. Let's basically understand what ordinances are. First things first, you must understand that the president and the governor have exactly equal powers when it comes to ordinances. The article numbers are important. President is 123, governor is 213. It's an interchange of numerical positions, so it will be easy for you to remember, right? So president and governor ordinances under article 123 and article 213. Now let's understand this in a simple form. I'll first give you a 1 or 2 line definition, then I'll give you the procedures for this. So ordinances are nothing but temporary laws which are drafted by Council of Ministers directly assented by the president or the governor respectively, in the absence of any house of the parliament or state legislature. Okay, simple. You will see an application of rule number 1, which is democratic mandate, in play here. What you must understand here is a very background and very simple concept, that for any law to become a law, a bill has to be passed by both houses, if it is the parliament, for it to become a law. Even if one house has lesser powers, as it is in the case of money bills, and an extended version of the money bills is the budget. This is the underlying principle. No law can be passed by the parliament by just one house alone. Now, even if, and we understand that we do not have permanent houses, our houses sit for 3 different time slots in the year. We'll discuss this in the parliament in detail. The BMW sessions, the budget, the winter and monsoon. We'll discuss this. The budget, the winter and monsoon. And if there is a gap between the 3, and there will always be a gap between the 3, this is where the houses are not present. Anyways, the second principle is ordinances of the president are coextensive with respect to the parliament, and ordinances issued by the governor are coextensive with respect to the state legislatures. This means the Council of Ministers at the center can only draft a law which is in the union list or the concurrent list of Schedule 7, and the Council of Ministers at the state, if they want to issue an ordinance, can do so only for the state list or the concurrent list. Under no circumstances, constitutional amendments can be introduced as ordinances, because constitutional amendments are not ordinary law. They are not law as per 13 clause 2, as we have discussed in the Keswananda Bharti case. They originate from what is called constituent powers. Now, why are they temporary? Because of rule number 1. The parliament or the legislatures are the final lawmaking body. The second is, why are they drafted by the Council of Ministers? Why can't any other MP do this? Is because after the parliament, the next best set of people are the Council of Ministers, who have a heightened mandate of the majority of the Lok Sabha. Third, they are directly assented because the president and the governor also have some form of direct or indirect mandate. The president has been elected by the center and the states, and upon the advice of the president, who has been elected by the center and the states, and the advice of the Council of Ministers, is the governor appointed. And it can only happen in the absence of either houses, because the lawmaking power lies with the parliament. Now, all of this should not happen under ordinary circumstances, under usual circumstances. This should only happen when there is a massive urgency in place. Only if there is a massive urgency in place. Now, what is the urgency? That is very subjective. And a lot of times the government can bypass the legislatures, wait for them to finish their BMW sessions, and then go through the ordinance route, because then the government does not have to face the questions of the House and show the people of the country directly that, you know what, this is the law we wanted to bring, now see how great it is. Last year, farm laws were originally issued as an ordinance. Then they were, of course, passed in September 2020, which of course carried on till 2021. And it was only in December 2021 that the government had finally repealed your farm laws in the just recently finished winter session of December 2021. Now, this of course is questionable in terms of why do you want to do this, but there is a reason why you have it. You have it because sometimes there could really be a necessity. We might really need a national law in place. Now, why are they called temporary laws? Because once the Council of Ministers have drafted the law, sent it to the President or the Governor, the law has been, the ordinance has been issued, the ordinance has been promulgated. The ordinance is like any other law and therefore can be judicially reviewed, can be questioned by the court. In fact, there were petitions which had originally challenged the Triple Talaq ordinance, which was then followed by the Triple Talaq law in the court. The Supreme Court dismissed those ordinances, those challenges or those cases, but you can go to the court questioning an ordinance. Anyways, then the ordinance is in force. It is in force until the next session, which is your BMW sessions of the houses, and from the day the house sits, you have 6 weeks to pass the ordinance, and the maximum gap between two sessions can be 6 months. So let us say, for example, hypothetically, the winter session finished. The day the winter session finished, the next day you introduced Ordinance 1. Ordinance 1 can continue for a maximum period of 6 months plus 6 weeks, because within 6 months the budget session has to begin. We of course do it at much shorter notice, and once the session has begun, the Parliament has to pass the same law within 6 weeks. Here it is Parliament or legislatures respectively. Okay. If they don't pass it in 6 weeks, even if they don't consider it in 6 weeks, then of course the ordinance will be lapsed. It will no longer be in function. It will no longer be in force. And because of this, there are always two fundamental questions that can arise. That let us say the government, the houses don't pass the ordinance. Session goes, then the government can reintroduce the ordinance. Then session happens, they don't pass it, then they can reintroduce, then they can reintroduce, and so on and so forth. So there are actually two very important questions that come into play. The first question is, can an ordinance be reissued? And another word for reissued is re-promulgated. If yes, how many times? If no, why not? And the second question is, if the ordinance has lapsed, what happens to the effect of the ordinance which was in place till the time the ordinance was in place? These two questions then give rise to a larger question. Isn't this basically violating separation of powers? That the Council of Ministers are essentially making a law without the Parliament. You are performing a core legislative function, bypassing the Parliament. And isn't this a violation of separation of powers? So these are the three broad issues that are usually from an ordinance perspective, and of course the whole urgency debate sort of merges into these three issues. Okay, so these are your basics of your ordinances. They're exactly the same. There's nothing more than this that is asked in the prelims, but in the mains there is a lot more that goes on. I will of course give you 2 minutes to take a note of this, and then we'll move to the mains part of our discussion. Thirty more seconds. All right. We are going to be discussing ordinances as an extension of the third point of your main syllabus, which is separation of powers between various organs, dispute redressal mechanisms, and institutions. Okay, now if you see, there have been a few questions that have been asked from ordinances. Let me show you the questions and then you'll understand how does the mains really go about it. Ever since 2013, since the pattern has changed, there has been first one question here, which was resorting to ordinances has always raised concern on the violation of the spirit of separation of powers, wherein they're supposed to be away from each other, while noting the rationale, justifying the power to promulgate. While I understand that there can be an urgency of sorts, analyze whether the decision of the Supreme Court on the issue has further facilitated to resorting to this power. There was a recent judgment and we'll come to that. And of course, should the power to promulgate ordinances be repealed entirely? Here, of course, you will take the middle path. So this was a question here. Okay. Now, second, if the houses are not in session, they can't reject or pass anything. And if it's rejected by one house, the ordinance obviously fails. It's like any other law. Now, second, when we look at the question, do you think the Constitution of India, do you think that the ये किसी ने ऑन ऑफ किया था क्या? नहीं, लाइट ऑन ऑफ किया था, लाइट बंद की, इंटरनेट बंद कर दिया आपने? All right. Sorry. Thank you. There was a slight voltage fluctuation. This was a tech error from my end. I'm sorry for this. Anyways, so as I was saying, that There was a direct question on ordinances in 2015, which basically asked you how ordinances violate separation of powers. 2, what is the reason behind it? 3, has the Supreme Court's decision affected it? And 4th, should the ordinances power be repealed? Should there not be any ordinances? And of course, we should follow a middle path. Now, apart from this, there was a generalized sort of a question on separation of powers and checks and balances, and ordinances could be one of the examples given in 2019. Now, we'll start with ordinances directly, and I'll come back to this separation of powers once we are done with the parliament also, right? So let's move to ordinances. Now, as I was telling you, I will quickly run you through the notes and sort of make you understand what is happening here. So first is the definition that you can write in your mains answer. Ordinance is a law which is promulgated by the President on the recommendation of the Cabinet when the Parliament is not in session. You have similar powers for the Governor under Article 213, whereas the President gets it for 123, right? Of course, here also I've explained this from a state legislative context, where we're understanding that the Governor also has the powers to do this with respect to the states. If, for example, either there is going to be a state which has a state legislative assembly, or it's going to be a state with a state legislative assembly and a council, or there is going to be a union territory with the legislature, wherein you're going to have a legislative assembly. Here the lieutenant governor gets the powers, here the governor gets the powers. In this case, either of them, even if either of them are not in session, the ordinance cannot be, the law cannot be passed. What is also very interesting to notice, and we'll study this later in detail, that the legislative assembly of the states can always override the council in all matters. What is true for Lok Sabha and Rajya Sabha only in the case of the money bill is true for all laws for states which have 2 houses. But despite that, even if one of them is not in session, then the law cannot be passed. So that is the integrity of our parliamentary systems that we must absolutely appreciate. Okay, now the question is, why was this introduced, the rationale behind this, and why does it make a lot of difference? The rationale behind an ordinance making power, okay, the rationale behind an ordinance making power is basically that the executive is able to meet any unforeseen or urgent situation arising in the country, which could be any exigency when the parliament is not in session, and it cannot be dealt later with ordinary law. For example, when the country expressed its deepest disappointment in the Nirbhaya case, and the government had appointed the Justice Verma Commission, which had recommended some groundbreaking changes to our criminal laws, and some of those changes, such as criminalizing of offenses such as stalking or voyeurism, and making a gender neutral offense of rape, and also at the same time making changes to juvenile justice, where for serious crimes adults and children should be in fact treated the same way. So for all of those reasons, you had to come and pass an ordinance, because the parliament was not in session. The winter session had just ended, and the budget session was still about 2-3 months away. So as a result of this, to have the criminal law ordinance in the context of the Nirbhaya gang rape, which happened in November, December a few years ago, it made a lot of sense. But there was nothing urgent about farm laws. There was nothing urgent about triple talaq ordinances. You could have done it when the parliament would have come to power, come back to session, and you could have still gone ahead with it. So of course, it has to be unforeseen, it has to be urgent. And the historical context is, this has been taken from the Government of India Act of 1935, which has vested parallel legislative powers in the Governor General of India, which of course gets replaced by the head of states. Now, of course, the duration of an ordinance, which means it could be in force until the next session happens. And you must understand this, nowhere does the parliament, now originally it was that the parliament should meet once a year. Then through the debates we figured out that once a year is too less and the parliament should meet at least twice a year, and that's why the 6-month gap sort of is the provision in the constitution. Now technically until the next 6 months the house is not supposed to meet. Now, so originally the original idea of the number of times a parliament met in a year was 1, then it became 6 months gap, and how we actually implement it is with 3 sessions a year. Nowhere does it mention in the constitution that there must be 3 sessions a year. What is mentioned in the constitution is that 2 sessions can't be 6 months apart, more than 6 months apart, and that is still a very long duration for a law to be in force which does not have the sanction of the supreme lawmaking body, which is the very parliament. Now in 2021, in the last the most recent session, there were 3 ordinances which were in the news. None of them really had a lot of implications per se. So there were 2 with respect to certain bodies. First was with respect to changing the director of CBI's tenure, and the second was changing the director of ED, which also Enforcement Directorate, which comes under the CVC's tenure. And there was a minor technical or a typographical change in the narcotic drugs and the psychotropic substances. There was a drafting error that had to be changed. Of course, there were questions raised on why do you need an ordinance for this? The justification was because we wanted to extend the tenure of the CBI director for 5 years. Otherwise, we'd have to appoint somebody else, and that could be a loss to government functioning. Okay, so this is the basic context to what it is and why we're understanding this. Now, it's very important for you to understand a little bit of data. Now, the data is, see, one could say that in coalition governments, you could possibly see more ordinances because they are fragile governments. But in majority governments, you should technically see lesser ordinances because you have a larger sort of a support, right? A larger sort of a support. Now, very interestingly, this hypothesis is actually not true when you look at the data with respect to ordinances in India. So, for example, between 1952 to 2014, since the first Lok Sabha till 2014, which is pre-Modi Lok Sabha, governments had issued about 637 ordinances, and that averages to almost 11 per year, or almost 1 on a year, on a monthly basis. And these are they're extremely high numbers, because if you compare the US, the Canadian, the New Zealand parliaments, they are throughout the year parliaments. They're always in session. So you can call a sitting for the parliament whenever you want to. In India, we have a budget, monsoon, winter session kind of a setup. Now, there are about in the initial sort of 14 years where you had an absolute majority kind of a government, still you had about 70 ordinances. And of course, in just 6 years, this is especially during the emergency era, you had around 77 ordinances in the years 71 to 77. If you look at the last 6-7 years, on an average in 2021, we had 10 ordinances. In 2020, we had 14. In 2019, we had 16. These are not very good numbers. 2018 was 9, 17 was 7, 16 was 10, 15 was 9. On an average, it's all between the 9 to 10 range group. But 2012 was a very good year where we had just one ordinance. This is just some fun facts in case you want to quote them in the mains for some brownie points. But the first ever recorded ordinance in India is the Indian Paper Currency Ordinance of 1918. The first recorded ordinance of independent India is in fact the Press Ordinance of 47. And post the enforcement of the Constitution, which is 26 January 1950, one of the first was the Parliament Prevention of Disqualification Ordinance, which later on added certain provisions to MP, MLA disqualifications because it was passed by the Parliament within the stipulated time period. This sort of broadly explains to us as to why ordinances have always been a reality of India, irrespective of the format of government. And that hypothesis is broken. So with this data, in your mains you can write, India on an average has witnessed 10 ordinances on a yearly basis, irrespective of the format, irrespective of the composition and the majority at the government. This is just unrealistic. And this is just unacceptable, which is why it becomes a matter of grave concern. Now, once we understand this, let's understand the ordinance making power, which I have already explained to you. You can make like a flowchart of this sort in your mains exam and quickly cover the important points. I'm not going to waste your time with this by going through this again. Now comes the analysis part. What is the basic comparison and what is its impact? See, the first thing is you must understand just because it's by the president does not make it an executive act. I understand the president is the head of the executive, but this is not an executive act. This is as much a legislative act as anything else, which is why it is a law within the meaning of the Constitution. So you cannot violate a fundamental right. The ordinances can be judicially reviewed. Their validity can be questioned in a court of law. And that is why this power of the president is coextensive with the legislative power of the parliament itself. It is coextensive with the legislative power of the parliament. We've covered this before, right? Now, the basic difference is, you see, whether it is an executive act or a legislative act, a lot of times, see, in all executive acts, the Council of Ministers are advising the president or the governor respectively. And laws are often drafted by the Council of Ministers. I understand that. So whether it is an ordinance or a regular legislation, I understand even in the case of an ordinance, it is the Council of Ministers who are drafting it. But the difference is that in the case of a regular law, this is done on a current basis, right? Current basis that the parliament is currently passing the law. But in an ordinance, the parliament is passing the law after the law is being enforced. In an ordinance, the parliament is passing the law after the law is being enforced. In a regular law, the parliament is passing the law only after which the law can be enforced. And this is, of course, a legal terminology called ex post facto. Anyways, now, of course, unlike a regular bill, an ordinance is immediately written, drafted, signed, and moved on. So you have a lesser discussion, a lesser deliberation, no consensus buildings. Similarly, an ordinance can be on anything that the parliament can make laws on. So the parliament can ordinarily make a money bill, a financial bill. So can the state legislatures. The only thing is ordinances cannot be constitutional amendment bills. And also, because it's like any other law and law is judicially reviewable, so ordinances are also judicially reviewable. Like I explained to you, the Farm Law Ordinance or the Triple Talaq Ordinance, right? And of course, you must understand that here there is a little bit of separation of powers, wherein while I understand that you can't get into the intention of why an ordinance was being passed in a court of law, but you can always look at it in terms of whether you have the legality to pass an ordinance. Is it even a legal order? Is it even legal in nature? Which is why when the Council of Ministers are drafting an ordinance and sending it to the president, can you question the satisfaction of the president? If so, to what extent? We'll come to some judicial decisions on this, and you'll be able to understand the overall picture just about soon enough. Now, the Supreme Court has primarily given 3 judgments, right? The first judgment is, of course, the R.C. Cooper case. We've discussed the same case in Kesananda Bharti also, wherein there was a nationalization of banks issue, and it was first done through an ordinance. So R.C. Cooper had also challenged that what is so urgent that you need to nationalize through an ordinance? You want to nationalize a bank, you can do it through a normal law. What is the hurry that it has to be done now itself? To which the Supreme Court had very clearly said, that if an ordinance is passed, and the reason why it is passed, it is not requiring an immediate action, then of course the court can check on the urgency of it. And of course, because of this, they, in retaliation, in the 44th Amendment, they added a clause where said that the satisfaction of the president is not judicially reviewable. Okay. Then there are 2 cases. Both of them have relationships with Bihar. D.C. Badwa was a professor of economics at the Gokhale Institute of Politics and Economics in Pune, one of India's most underrated institutions for economics, but fantastic beyond doubt. They're brilliant in what they do. So he was a professor, and he had basically filed a case with respect to certain developments that were happening in Bihar. So basically, several ordinances in Bihar, right? They were with respect to certain basic legislative changes. They were just, so what used to happen was they used to introduce an ordinance, then the House used to not look at it, forget about it, they used to reintroduce it, House used to forget about it, they used to reintroduce it, and this scale continued, and ordinances were promulgated, re-promulgated more than 250 times. To which the Supreme Court said, boss, you just can't do this randomly. Just because the houses are not getting into it, that does not give you the leeway to do this open-endedly, right? And therefore, of course, the Supreme Court said, unless there is an absolute urgency, you don't have any reason to mechanically re-promulgate an ordinance. Then in the Krishna Kumar Singh versus State of Bihar, this was a 7-judge bench of the Supreme Court. This is where you have a lot of, you could say, a lot of detailed analysis on ordinances, which is why you will see in our previous questions, they referred to the Supreme Court judgment. This was the Supreme Court judgment that they were referring to. So basically what had happened here was, this is a very similar issue to what is going on right now, but has nothing to do with ordinances. You would have heard of a proposal in a state where they are planning to nationalize or all religious institutions, all madrasas will become what are called state government schools, right? All madrasas are going to become state government schools. And the teachers at those madrasas will now be state government teachers, and therefore will be given the same amount of salaries and perks as state government teachers, right? So something very similar happened with Bihar. The only difference was it was not about madrasas, but it was about Sanskrit schools. So about 20 years ago, what had happened in Bihar was they said all Sanskrit schools in Bihar are going to now be owned by the government, and this was done through an ordinance. So all teachers of Sanskrit schools will now become government teachers. They will be given salaries and pensions like government school teachers, and this was through an ordinance, and they kept re-promulgating it over and over again, right? To which this was challenged in the Supreme Court, and the Supreme Court said that, boss, you cannot escape from the legislature. It is where eventually all laws are supposed to end at. So please do not unnecessarily undermine the sanctity of the legislature. And it also said, as far as the larger question was, which was that what happens to the effect of the ordinance once the ordinance has been repealed or the ordinance does not exist. Then the court basically gave 3 tests. The 3 tests were, first, that the effect of the ordinance must be irreversible, which means you can't reverse the effect of the ordinance, which means it is impossible to take back what the effect of the ordinance has been. 2, if you do reverse the effect, it is unnecessarily impractical. It is a decently good thing to do. And third, that there is a very strong reason in public interest, that even if the parliament is not looking for it, but it's still in public interest for the ordinance to continue, which gives the powers to the Supreme Court to decide whether this is in public interest or not. And this, of course, has a larger question on activism and the role played by the court in determining what is public interest. And that is something that we could, of course, look at in some amount of time. So these are the broad things that we had to understand. Once we have, now we look at, is it an abuse of parliamentary democracy? If not, why not? So I have given you a sort of arguments here. A set of arguments are, first, in reality, while the power is of the president, it is actually with the cabinet or the council of ministers. They are the ones who are actually doing it. But the question is, they have to recommend to the president, and the president has to promulgate, has to sign on it. And the president can say no, but the president will not say no because you're bound by the council of ministers' advice. Now, the question is, how satisfied is the president that, okay, this is truly urgent and this needs to happen? And this, of course, is a very subjective matter. And unfortunately, this subjective matter cannot be questioned in a court of law because of separation of powers. It is very subjective. Motive is very subjective. And therefore, this precise nature of what should be done, should not be done, this discretion cannot be challenged. This is also very similar as to how the judiciary can't get into why a law was passed, but also only can look at the validity of a law, right? Now, similarly, what has happened is, the increase in the number of ordinances has, of course, led to a larger debate that, are they really bypassing democratic institutions or not? I've given you the judgments in a summarized form, and your concluding statements, your sort of opinion should be that the power to promulgate an ordinance is a very rare power. It's an extremely it's a power which should be used in the rarest of the rare cases, and under no circumstances should this be taken as a first resort to action. And second is, I spoke about this, what you can't do indirectly should also not be done directly, or what can't be done directly should also not be done indirectly. So if you are, if the law does not want you to repromulgate ordinances, don't abuse the law by changing the small text or changing the heading or changing the section numbers. Don't do these formatting changes also to show on paper that the ordinance is actually a different one. Right? Now, apart from this, what else should you know? In case the satisfaction of the president cannot be questioned, then how do you look at what is right or wrong? And that is why you could look at the material evidence that the president has relied on. That the president would have referred to something. There must be some circumstances on the basis of which the president's satisfaction can't be questioned. This is like the court trying to hold your ears from here. I can't question why you did this, but I can question the reasons on the basis of why you did what, right? Which is exactly what I have written here, which is nothing but that, of course, you can't get into the examination of questioning the consent or the assent of the president. But of course, you should definitely be looking at material powers. Apart from this, I have also explained to you in 3 very specific points as to why there are a higher cases of ordinances. First is that there's a reluctance to face the legislature. Second, if the Rajya Sabha rejects the bill, then your bill is flattened out. There has to be a joint session only if you want to. And the third is that you want to overcome the standoff in the legislature by repeated disruption, or you just don't want the opposition to unnecessarily stand up and oppose the bill just because they're the opposition. And sometimes parliamentary disruptions are very, very fatal, right? And of course, we've covered the Krishna Kumar case, where I've explained this in a fair amount of detail. Now, always remember, there's always two sides to the story, and the two sides of the story is what your conclusion should be. So, this Krishna Kumar judgment, of course, allows the court to look into ordinances more. Second, the court can also get into what made the governor think or the president think. And third, it maintains a balance of democracy. Now, you must also understand, it is not always that ordinances are evil in nature, or you are trying to bypass the parliament. There's always another side. The other side is that the opposition often does not play the role of a constructive opposition, right? And therefore, what happens is the opposition would just unnecessarily, question the ordinance or question a law or question anything. So sometimes the disruptions of the parliament are reason enough for you to actually come up with an ordinance in the first place. So can ordinances be repromulgated? Yes. They must always be sent to the House. Can they be repromulgated? Yes. Can they be repromulgated in the exact same shape, form and size? No. There must be some substantive change in subsequent ordinances. What happens to the ordinance if it has been relapsed? I have given you the Krishna Kumar Singh judgment. Can urgency be questioned? Well, technically no, but the material on which you thought urgency is needed, that can be questioned. And this is largely what the mains part of it is. I don't think anything beyond this, as far as ordinances is concerned, will be asked in your pre or your mains exam. And this, of course, covers our first section, which is your powers. And here we have covered your legislative powers. Here we will finish up executive and judicial in 1 hour tomorrow, and then do an analysis of the governor in the second hour and finish it up. Thank you. Have a good evening. See you tomorrow.